obviously given a foundation statement of Patna and Tripura wrong. So which High Court will be bold enough to take a decision?
There's one more thing that we had done, which we have stated in one of the MAs already. There were two writ petitions pending in Patna and Hubli, to which we filed a transfer petition in Supreme Court, saying that this judgment will not really apply to us because this dealt with only this gave benefit or this reserved thing only for in-service. So therefore, since the question of law is same, please transfer these things to Supreme. Justice Oak had it. And he issued notice granted stay. That will also ultimately follow this.
They have to come out.
If it is. As of now, it is with Justice Oak that it got transferred to this court.
It is too late.
We put proof that all of them were in service. Somewhere down the line, there seems to be confusion. That there seems to be a confusion in their mind that it was only for in service, but all of us are in service. There is no question of not being in service. That we put proof. So
That's a precondition.
that's the precondition for any person taken in IAON service.
What do you say? Sure. Wait, please, Manoj.
This year, there are 9 MBAs. I've been in the MBAs for 100 candidates who have not been participated in 6 years.
So your lordships are well aware of what transpired. What's this review petition? While they're not all parties, it covers and will have an impact on about 12 lakh teachers who were in service at the time that the RTE Act section was amended.
So that is what we have held that that special 18 months course
Yes.
was for protecting the teachers who are already in service.
Correct. So
But it can't be made applicable for future employments. That's what we.
yes. So if I may, the idea, Manoj, was simply this: that in curriculum and in everything else, the program is exactly the same, including the internship period. It's a 24-month program.
No, it's a 18 month.
No, the program that has to be followed as has been laid down by NCTE is a 24-month program. Now, the relaxation that was provided to ensure that they fall within the timeline because the section 27 was amended and the proviso was included, which allowed those in service to complete by 31st March 2019, which required it to be completed in less than 24 months. So that's why the relaxation was brought in so that they will finish in 18 months. Now, what has happened is, Malons, this, that 18-month period is being treated as equivalent not by the Uttarakhand High Court. Your Lordship judgment says that the High Court couldn't have gone in and created an equivalence. That perhaps is not what I think would be borne out from the record, Malons, because there were actually an expert committee that had been set up by NCTE. All this took place on directions which were directed by the central government by exercising its powers under Section 29. There were advertisements which were issued with the Prime Minister's photo on it, saying that please ensure that you will complete this by 31st March 19. The idea was that once, as an in-service teacher, I get that qualification of 18 months, it is exactly the same as anybody else getting a 24-month qualification. Now, the effect, Malons, of your Lordship's judgment is that in schools, for example, which have gone through the plight of COVID, who have had to close down, etc., those teachers, when they step out and they apply, they are told that, sorry, this is not being treated as equivalent to the 24-month. That is the problem. It is, in fact, I just wanted to show your Lordship 3-4 documents, which will show what the background is. What took place is, and all this took place over a